As many of you know, ALI is an extremely influential organization. The restatements of law and principles of law are considered by many to be the most credible, definitive interpretations of where the law stands today. Obviously, these publications are important for all litigants. But as you'll hear, many of ALI's current projects are of special interest to the business community, and that's why we're very lucky to have with us today the new director of ALI, Richard Revesz. He's currently the Lawrence King Professor at New York University School of Law, where he previously served as dean for 11 years. He is a very distinguished scholar of environmental and regulatory law and policy. He focuses on cost-benefit analysis, the allocation of regulatory responsibility in a federal system, and the design of liability regimes. And he's twice received the ABA's award for Best Book on Administrative Law and Regulatory Practice. So join me in welcoming the dean.
Thank you so much for inviting me to talk to you today. After Lisa's really nice introduction, I think I should probably just quit and I'll stay ahead. So the ALI describes itself accurately as the leading independent organization in the United States producing scholarly work to clarify, modernize, and otherwise improve the law. And I thought I'd give you a sense of the different things we do and also the ways that you, the business community, can have an input in what we do. So first, the things. There are basically three categories of projects that we put out. We're best known for our restatements. Restatements are aimed primarily at courts and deal primarily with sources of positive law. What a restatement is a mystery to some. I'll give you a sense of how we think of it. We think of a restatement rule as being what a great common law judge would do if that judge had access to a wide body of information and no time constraints, which real judges won't have in specific cases. Typically, in putting together restatements, we look at four things. There are 50 jurisdictions, 50-plus jurisdictions in the United States. We will look at what the majority rule in the jurisdictions is, and that's the starting point. That's not the end point. Because, for example, it could be the case that there's a clear trend in the law. Maybe 30 jurisdictions went one way, but the last 20 jurisdictions to look at the issue went the other way. That might tell us that maybe there's a trend to abandon the prior rule. We also look at how a legal rule on a specific issue fits in with a larger body of law. Our goal is to clarify and simplify the law. If we find an outlier rule, we ask, why is it there? Does it make sense? And lastly, we look at the desirability of the rule. Are there empirical studies of the performance of alternative legal rules? Have we learned something on the ground in the states as laboratories of experimentation on what works better and what doesn't? Are there social science assessments of the efficiency of outcomes and so on? So basically those four things, the majority rule, the trends, how things fit with the body of law as a whole, and analysis of the desirability of the rule form part of the inquiry, and that's exactly what a good common law judge would do and has done since time immemorial. Second, we put out principles projects. Principles projects are aimed at institutions other than courts. They could be private actors, for example. Just at its meeting last Friday, the ALI Council, which is our governing body, approved a new principles project, which might be of interest to some people in the room, principles of compliance, enforcement, and risk management for corporations, nonprofits, and other entities. The goal of this project is not to come up with legal rules that will be enforceable by the courts, but essentially is to come up with what would look like best practices for entities, both in the for-profit and the not-for-profit sectors. The third thing that we do are uniform codes, and mostly our work in this area has been limited to two. One, the Uniform Commercial Code, which we do in partnership with the Uniform Law Commission, and second, the Model Penal Code. So restatements, principles, and model codes, that's the bulk of what the ALI does. Our influence. Luckily, we've been extraordinarily influential because of the painstaking nature of our drafting process, which I'll tell you about in a minute. In the last term alone, the U.S. Supreme Court cited our restatements in 15 of the roughly 70 cases it decided on the merits, so roughly 20% of the cases. And in some of those, the restatements actually played a significant role in the Supreme Court's decision. As you might guess, we keep track of citations to our restatements and principles projects in the courts. And to date, this is as of June 2014, they've been cited 195,073 times in the courts, not just in the United States, but overseas as well. Our two most influential restatements have been torts and contracts. Certain rules, some states, for example, have adopted the restatement of torts as the tort law of that state. Our strict products liability rule in the second restatement was adopted at least in part by a majority of the state Supreme Courts, and some state legislatures have incorporated into their statutes. The Uniform Commercial Code is generally viewed as one of the most important developments in American law, and in whole or in part, with some local variation, it's been adopted in all 50 states, the District of Columbia, Puerto Rico, and the Virgin Islands. We have a number of restatements and principles projects going on now that could be of interest to people in this room and to people you work with. We have an insurance law project, which will now be a restatement of insurance law. There's been significant input from the various groups interested in this issue over the years. On the principal side, I mentioned our corporate compliance project. We have a project on data privacy that's going on. If you look at our website, ali.org, under projects, you will see a list of our 13 ongoing projects, and very soon you'll see a list of the 5 projects that the ALI Council approved last Friday. And for each of these projects, there are all kinds of documents available online, our various drafts, comments that were filed, and so on. Okay, who does this work? So we're an organization of prominent lawyers, academics, and judges. We have roughly 4,500 members. 50% of them are practitioners, 37% are academics, and 13% are judges. The governing body, the council, has 65 members, and approximately half are practitioners and a quarter each are academics and judges. What's the process for producing this work? When a project is launched, my job as director is to basically figure out what projects should be launched and make recommendations to the council. And I make recommendations on both the project and the reporter. Projects and reporters are approved by the ALI Council. Once the project is launched, the reporters will get an advisory group of prominent practitioners, academics, and judges. And they will meet with the advisory group at least once a year, and the advisory group will comment on drafts that will be prepared by the reporters. In addition, there's something called a members consultative group. The advisors are appointed by the Council of the ALI. Members consultative groups self-select among ALI members. So basically, we post these things on our website. Anyone who's a member of the ALI who wants to be part of this, of the group that advises the reporters can sign up for that. The reporters don't decide on the content of the restatements or the principles projects. They just prepare drafts. We have a bicameral approval process. Anything that ends up being the work of the American Law Institute has to be approved both by the council and at an annual meeting. So the council are these 65 members in our governing board. We just had discussion of portions of 5 projects. They take this stuff very seriously, and at the end of the day, take ownership for the work product. We have an annual meeting a year. Roughly 600 to 800 members show up. Everyone votes. Motions are made from the floor. The motions are voted on. And at the end of the day, for something to be a product of the ALI, it has to be approved both by the council and by the annual meeting. And often what's approved is not identical. I mean, hopefully it'll be somewhat similar, but not identical to what the reporters recommended. How to get involved? So we pick advisors. Once a project is launched, I will consult with the reporters, with the council. I'll make recommendations and advisors. We are very interested in getting in our advisory group people who are very knowledgeable, who are leaders in the area. We're less interested in people who want to represent a perspective if they are not themselves experts in the area. We're very interested in getting experts involved in that. We're very interested in getting experts in our members' consultative groups. We also, for many projects, have liaisons from interested organizations. If, for some case, an industry association wants to have an industry liaison to one of our projects, we're delighted to do that. If the Institute for Law Reform wants to have a liaison to one of our projects, we're delighted to make that happen. And I'm happy to be the point person, because now you know how to find me, to facilitate that. We are also interested in making sure that the views of the business community sort of pervade the work of the Institute. We made an effort in the last few months to make sure that prominent general counsels of major entities are members of the ALI. And if any of you who are members think, and there are a number of members in the room here, think that general counsels of prominent entities would actually be interested in participating in our work. And participating in our work essentially means reading drafts and commenting on them, because that's the work that we do. And one problem sometimes is the time necessary to do that. But if people are interested in participating in our work, we'd like to have them be members of the Institute. There are prominent members of the business community who are in the leadership of the Institute. Ken Frazier, the CEO of Merck, is on the council of the American Law Institute. Laura Stein, the general counsel of Clorox, is on the council. My deputy director, Stephanie Middleton, was the general counsel of Cigna, and she always keeps me honest and points out what she would have told me when she was the general counsel, and I always pay attention to what she says. And I'm actually serious about that. So there are many ways to interact and to get involved. And I was asked to maybe cede some of my time to help get you on schedule, but I would love to take a couple of questions and answer any queries, doubts, or things you'd like to know about the ALI. I see a hand back there.
I'm a member of the American Law Institute now for about 15 years and have admired much of what it's done. But one thing that has confused me all this time, we have clear systemic legal failures, what we just heard about in the first panel, and you've just mentioned the UCC as being the premier product of the American Law Institute. That was what I worked on, and frankly, the amendments flopped. They failed. They haven't happened. Now, in view of these systemic failures, it's always seemed to me that what the ALI should do, one thing that it needs to do, is like any legislative body in most parts of the world, look at how other countries do things. And the one thing that's been nearly missing completely, we've had the International Procedure Project, but by and large, the ALI has never introduced as a regular portion of its study project a view of how other countries do things. And frankly, other countries often do things better. Why hasn't the ALI introduced that?
Okay, it's a great question. I'm glad you asked it. And it's a great time for me to come and talk to you, because I became the director of the ALI on May 22nd. So, if you don't like something we've done, it was before my time. I'm just kidding. But seriously, I'm actually very interested in that. If you read the memo that I wrote to the ALI Program Committee and Council, which you couldn't have read because I didn't distribute it broadly, but one thing it did say is that we should pay attention both to the influence of our work overseas, which it does, but also to collaborating with institutions focused on these issues around the world. One thing that my predecessor, Lance Liebman, did was help form the European Law Institute. And the European Law Institute is actually interested in doing some of the same work that we're doing. We're interested in collaborating with them for every new project. For example, we are launching a restatement of conflicts. I've urged the reporters, and we will do that, to pay attention to the impact of these rules overseas and to look at how other countries deal with issues like we deal with. So I'm very sympathetic to what you say, and I hope that as you watch our work develop, you will recognize some of your concern actually reflected in the work that we do. Yeah. I saw two hands on that table. Okay, Victor, and then the person sitting behind Victor, who I can't quite see. Victor Schwartz, and I'm grateful to Victor for having suggested to me that this would be a very good idea.
It is. As you and the ALI have something in common. You both really understate your power. As you look to the future, what are some of the things, other than the international aspect, that you see for the ALI? Do you have some goals for it, taking it over after 91 years, but being in a new generation to take it over and have the capacity to make change?
Well, let me tell you something about, so we launched 5 new projects. So I'll give you a sense of what we're doing. A principles project on corporate compliance, restatements of property, which is an area that had not been looked at for a very long time, of conflict of laws, of copyright law, which is an area that that we haven't, typically we stay away from statutory areas, but we're taking this on because we're interested in taking on statutory areas that have, where there's a lot of room for judicial discretion. And we're going to focus on the parts of the copyright law where, like fair use and so on, where there's a great deal of room for judicial discretion. I'm interested in the international component. I'm interested in paying attention to empirical evidence about the functioning of legal rules. I think that's important. There's a lot of learning out there now. I come from somewhat of a social science background, and I'm interested in that. I'm very interested in we've played traditionally a leading role in areas of private law, like torts and contracts. I'm interested in the role that we can play in areas of public law, and we'll be looking at that, and hopefully projects of that sort will emerge. I'm looking at how we might be influential outside the United States. For example, were we to do a project on international trade, for example, which is not currently on our plate, but it might be someday. Would we want to be influential only with the U.S. courts, or also with the WTO, with the European Court of Justice when it considers issues like this, and so on? So those are some ideas that are currently floating around. At the end of the day, when we look at projects, it's not just, is this a good project, or is it an area that is crying for some reform, but it's also, do we as an organization have a comparative advantage in doing it? There may be good projects and good ideas out there that other organizations can do better than we can, and if that's the case, then it's not a good project for us. So, for example, we are not, it's not our comparative advantage to give advice to legislatures, and I don't think we would ever get involved in a project where the primary beneficiary of advice was the U.S. Congress. The state courts are somewhat different, although, again, the UCC is a joint project with the Uniform Law Commission, and in some sense, they have a comparative advantage at pushing some of these ideas through the state courts. We actually don't. So we pay a lot of attention to that as well in the choice of projects. Yeah. Okay.
I'm Richard.
You get the last question.
Okay. I'm Richard Falk. I'm a member of the ALI. Thank you very much. And there's a project that I've learned about. It's been bubbling for a while within the ALI. It's about to go to a preliminary publication in the Columbia Journal of Law and Public Policy, I think. And it's a proposed restatement effort or a statement of principles of environmental law. And it's something that, as an environmental litigator and an environmental lawyer, I'm very concerned about. I've participated in some of this. And I'm wondering, since environmental law is such a heavily statutory and regulatory matter, it just doesn't seem appropriate to me as a restatement subject. And I'm wondering if you have some comments
Sure.
on
I
that.
have lots of thoughts about this. Environmental law is my field as well.
Okay.
And because it is a very heavily statutory and regulatory area, it does not seem appropriate to me as a restatement subject. And the fact that there are people who, I get proposals for projects all the time. The fact that people propose projects doesn't mean they happen. For them to happen, I have to be on board and propose them to the program committee and the council, and that has not happened. And, you know, I don't want to get ahead of a formal decision, but I've given you my perspective on the issue. I don't think you need to worry about it very much. I really enjoy being here. Thank you very much for having invited me.